Bransten v. State of New York, counsel.
Your Honor, may I reserve 3 minutes, please? May it please the Court, Judith Vail for the State of New York. This case is about an across-the-board increase to the price of health insurance premiums for all state employees who purchase plans from the state. Such even-handed price increases do not violate the compensation clause, whether premiums rise because the state decreases its percentage contribution.
So let me ask you this. If there was a 25-cent reduction in salary, you agree that violates the compensation clause?
I do, Your Honor, because...
Okay, so if the premium hit that the judiciary has to take is 1,000-fold that, you say that, though, is not a violation of the compensation clause.
That's correct, Your Honor. And that's because when it comes to salaries, which are really the core of the compensation clause, there's no de minimis reduction that is constitutional. And that's because it's what the core of the compensation clause is about.
So a 10% reduction for every state employee hits judges, it's a violation.
For salaries, correct. There's no...
Is there anything other than salaries that you would consider compensation?
Well, the history of the compensation clause makes clear that salaries and permanent payments that are similar to salaries, such as just giving everybody $5,000 to go spend, no matter what insurance they buy, those kind of permanent payments are akin to salary.
I haven't gotten any check for $5,000 recently, so can you point to anything particularly that you would characterize that's other than a salary that would be called compensation? Because it doesn't say salaries, it says compensation.
That's correct, Your Honor. Two things. I mean, I think the word compensation was used synonymously with salary throughout the history of the clause. But when it comes to 2 points...
I'm more interested in an example.
Sure, Your Honor. Well, I will say this. I think it's been the case for a long time that not everything of value is compensation under the compensation clause.
What about pensions? What about you have a non-contributory pension plan? That's your deal. And now we take it away from you.
Pensions have long been considered akin to deferred salary. So I think pensions would be an example of something that is much more similar and probably does count as compensation.
What about the lump sum in lieu of per diem in the Box v. Wemple case?
The lump sums are permanent payments that are akin to salaries. If the legislature creates a permanent payment that goes to everyone, no matter what expenses they incur.
When you say permanent, what do you mean?
Sorry?
When you say permanent, what do you mean?
It doesn't fluctuate depending on the expenses that an employee might incur. And this is a distinction that this court
Well, originally
drew.
it did. I mean, the per diem you're talking about is a replacement of what you're calling fluctuating per diem that depended on the actual expense. Isn't that the history of that case?
Well, the history of the reimbursement cases is that this court looked at the specific features of what was going on and drew a distinction between reimbursements that fluctuated depending on what a judge might incur at a particular time, and permanent payments that didn't fluctuate.
Well, because the permanency is whether or not you say so, right? I mean, it's whether or not it's permanent because you're never going to take it away, which is a little bit of a circular argument. But isn't the point of that case that it's remuneration for expenses incurred?
I don't think so, Your Honor, because this court drew a distinction and said that when there are reimbursements that are being given to judges after they incur the expenses and they fluctuate, that those were not themselves protected compensation. And I think when it comes to health benefits, I think it's important to look at the feature that's actually being challenged here, which is the percentage contribution rate of the state's contribution going into the fund.
That's a good point. Let me take one step back for 1 second on it. Because Judge Garcia's point I thought was important when he said pensions. I think that's correct, that pensions could be considered compensation, just thinking out loud. And that's because the linkage that we're looking for between the compensation in whatever form it takes and the judges is whether or not taking it away would undermine the independence of the judiciary. And isn't that, it does, for instance, taking away a pension could actually do that. Isn't that the linkage that we're looking for here?
I do think that the core purposes of the compensation clause play a key role in this analysis, and that when it comes to pension, especially because it has long been considered deferred salary, that diminishing that could be seen to actually, or at least have the appearance of affecting the independence of the judiciary. But price increases to premiums that apply to all employees are a very different matter.
Just to take Judge Fahey's point then again back even one step further maybe, isn't the analysis come down to, is this a direct or an indirect effect on compensation? So if it's a direct effect, and Judge Rivera's initial question, then you don't look at what's the intention, are you being treated differently? It's a compensation violation. If it's an indirect effect, then we get into, well, it may not have been intended as it wasn't in Social Security and Hatter, but it may give the appearance of calling out judges or targeting judges in a way that would violate the compensation clause. So isn't one of the real issues here, is this a direct effect on judicial compensation or indirect?
I agree with that, Your Honor, and I think to do that analysis, it's important to think about what is the compensation that you're referring to understand if this is a direct diminishment of that compensation. And I think we all agree that salaries are protected
Right. So is
compensation.
this more like a Medicaid tax, or is it more like, you know, a pension benefit, health care, closer to pension, or is it more of the pure indirect, you know, Social Security analysis, Social Security tax analysis we're doing? And doesn't this really kind of fall somewhere in between?
It may not fit in a particular box, but I think when it comes to talking about the effect on salary, this is clearly an indirect effect on protected salary. It's the same analysis that this court used in Littman, although the protected form of compensation there was retirement benefits. The idea was the same.
If the price of the insurance policies that the state is purchasing from outside companies doubles, and the state says, we don't want to pay double, we're just going to pay the amount to these companies we've been paying before, is that a compensation clause violation?
No, Your Honor, I don't think so, because when it comes to the prices, there are many ways that the prices can increase to employees, and the effect here of reducing the percentage contribution is similar to the premiums, the premium costs in the world just rising over time. The effect on judges is the same, but plaintiffs concede that a year-to-year premium increase is constitutional as long as it's applied to everyone, and the effect here on judges is the same. When the percentage contribution goes down, the effect is that the price that employees pay goes up, and it is true that some money comes out of your paycheck to cover that higher cost.
Well, does it matter if we know to know why the percentage cost went down? That is, if the percentage cost goes down because the state says we don't want to pay as much as we've been paying, does that matter? We want to reduce the amount we're spending on insurance, and we're cutting it from, we're paying $100 million a year, overall, we're going to cut that to $50 million. Does that matter?
I don't think it matters in the constitutional analysis. Certainly it would matter if there was some evidence of intent to target judges. But when the intent is clearly even-handed, this court has been very careful not to generally look at the intent of the legislature, except for targeting.
And that answer depends on the health insurance not being compensation.
That's correct, Your Honor. And to move through the sort of boxes of what compensation we could be talking about here, when it comes to salary, I think this is clearly an indirect effect on that salary. And when it comes to health benefits, this court does not need to decide here whether all aspects or some conglomerate health benefit is protected compensation, because health benefit, they're made up of many different moving pieces that change every year. It's not just the premiums, it's also deductibles, copays, and the various benefits that go into the plan. And the court focuses on the aspect that's challenged here, which is the percentage contribution rate. That percentage is neither itself protected compensation, and reducing it shouldn't be seen as a so-called direct diminishment of some aspect of the health plan that might be protected.
So it's not compensation because you say it's not salary, which is the easy one, and it's not anything else that is the functional equivalent to salary. Is that where you are, or is there some other way you want to explain that?
Well, the percentage contribution itself is not compensation for several reasons. I mean, neither the percentage or the dollar amount that's actually contributed goes to judges at all. And what the percentage formula really does, and the point of a percentage formula, instead of giving everybody a set dollar amount, is to have the state's contribution in dollars fluctuate at a certain level as the underlying prices go
To
up.
say what you're saying a different way, just to make sure I understand it. If, for example, the state said, you're now going to have to pay a greater percentage, contribute a greater percentage towards the policies, but we're going to remove the $10,000 annual deductible and make that zero, it's not clear whether there's been a diminishment or not a diminishment. You're saying there's a lot of things that go into a policy, and so figuring out whether there's a diminishment at all is not an easy thing to do.
I agree, Your Honor. If you're thinking about health insurance as the possible protected compensation, it is very complicated to try to do that in some conglomerate level, because it's not clear that changing the percentage changes the overall value of the plan, especially when benefits often go up over time, and actually did go up in 2011 when this change was implemented.
I'm losing you there. I don't see the benefit writ large as a compensation, because they're paying for part of it, right? The judges pay for some, the employees pay for some of it. It is your share, what the state has decided it's going to put towards the premiums, which means that they pay less. That's their point, right? That the judges and all employees pay less because you're paying a share. Your argument is the share, well, the percentage stays the same, but the amount changes.
Well, I think there's two different arguments. One is when it comes to the percentage formula itself, it is true that even when the percentage formula goes down, it is not necessarily the case that the dollar amount that the state contributes also goes down. In 1983,
And the reverse is also true. Just if the percentage went up, that doesn't necessarily mean that the cost to the employee would go down.
That's also true. I mean, there's so many interlocking pieces here that as the premiums rise, as they have been over time, lowering the percentage rate, what it effectively does is slow the rate at which the state's own contribution is rising, but the state is not required to keep pace with prices over time. That's true even in the area of salaries.
It seems hard, though, if your argument is we parse a benefit to see what part of that benefit is compensation. So if we went back to pensions and we say it wasn't, hypothetically, it wasn't a non-contributory plan, the judge is paying $100 a month into a pension plan and getting a defined benefit. What if the state says, okay, now you're paying $200? So pensions, you say, are deferred comp, so it's part of comp, it's part of salary, it's a direct effect, but now are we going to parse that to a premium type of issue, or anything that affects pension because it's part of salary would be a direct effect and unlawful?
I mean, I do think pensions could be an entirely different category that don't need to be parsed because they are so connected to deferred compensation and were understood that way in the history of the Constitution. And pensions also have their own separate protection in the New York Constitution. I think health benefits are unique and they are very different from the pension system.
Aren't we then back to direct or indirect, and the things that you're talking about in terms of parsing premium is really the analysis of Hatter and the other cases on, if we follow it, on is this indirect impact violate the comp clause?
I do think we're still in the direct and indirect framework, but I do not think that reducing the percentage contribution should be viewed as a direct diminishment, even of some aspect of the health benefits that that might be protected. And that's because you'd have to start netting out other changes that might happen in the health benefit over time in order to decide whether the actual value of the plan went down. And that is a very difficult analysis to do. And these types of changes, rising in spikes in premiums over time, changes to copays, deductibles, they happen all the time. And they have never been thought to be violations of the compensation clause.
But isn't the reality that you are looking to pay less because that's what you negotiated, right? The point of the negotiation, or as I understood it, the state's in a fiscal crisis. They negotiate this exchange, along with some other benefits, of reducing the contributions to stave off some of the layoffs. It must represent some value, real value to the state, that they're saving some money, which means at some point somebody's picking up the difference. And in this case, it happens to be employees, and of course for these plaintiffs, it's judges, so they're claiming that's the violation of the compensation clause. Am I misunderstanding the whole point of that negotiation and that exchange of staving off layoffs for reducing
Well,
the
I don't think
percentage?
I mean, it's true that these changes went into effect as part of a broader plan to reduce deficits. But one of the reasons why the state looked to premiums is because premium costs are rising all the time for everyone, or have been traditionally rising for everyone. And so that motivation is not fundamentally different than simply increasing the premiums year to year because premiums are rising, because healthcare costs are rising, new technologies come out, new laws require new coverage. There can be many reasons why premiums rise, and it's not fundamentally different to raise the premiums to address those rising costs, even if the state has a particular need to save that cost at that time because of the deficit. And
You don't seem to have addressed the main argument of the plaintiffs, that when Civil Service Law 167 was enacted, subdivision 8, that the unionized employees had a quid pro quo for that in terms of a non-layoff promise, and that the managerial and confidential employees had at least a promise that they would receive some reimbursement for these amounts. Must you convince us that that these reductions do not affect salary in order for us to get around that problem?
well, the non-discriminatory aspect of this matters if the court decides that there might be some indirect diminishment. To be constitutional, that would still need to have been done even-handedly, and it was here. Everybody, all employees now, the unions have finished their negotiations. All unions, unionized employees, non-unionized, MCs, judges, are subject to the same contribution percentages.
And you say that's the appropriate class that we should be using to measure. I believe Supreme Court used all citizens of the state of New York. You say the proper class is all employees of the state of New York.
That's right. And the Supreme Court made that clear in Hatter, that when the state is acting as an employer, the only class that could really be affected are employees, and so it wouldn't make sense to look to all citizens. And that was the same, that's what happened with the Medicare tax. All other citizens had already been subject to the tax. It was only the tax immunity for federal employees that mattered. And here, everybody is subject to the same rates. And if the court wants to look at a bigger picture in terms of other terms and conditions that were being negotiated at the time, the bigger picture here is that judges were just as well off as everybody else, if not better, because everybody had their salaries looked at through the appropriate process. For union employees, that's always negotiation because it's required by law.
And isn't the test, though, whether judges have been singled out, not whether they somehow didn't get the same benefits as others?
That's true, Your Honor. I mean, the focus of the analysis really should be the financial burden or the financial effect at issue, and that here is the percentage contribution, and that applies for everyone the
Okay.
same.
Thank you, Counsel.
Thank you,
have
Your
a
Honor.
vote. You want one?
I have a jurisdictional issue
Oh, yes,
I'd like
please.
to.
Yes, okay.
I'm switching subjects a little bit. I'm sorry.
No,
I've got,
so you
I've
wanted
got-
to ask
I've
one
got
more
just
question,
a
yes.
question for you. I'm having trouble understanding how you are here on a direct appeal from Supreme under 5601B, which allows a direct appeal if the only issue raised is the constitutionality of a statute. But the declaratory judgment you're taking an appeal from is a declaration that both the statute and the regulations are unconstitutional. That seems to me not to comply with the statute. In addition, if you look at the statute itself, the statute doesn't do anything except vest the president of the commission with power. So it seems to me that the real underlying declaration here is that the regulations are unconstitutional, and that doesn't allow a direct appeal here from Supreme. Correct me, please.
I think there was a general understanding in Supreme Court that the statute here was the thing that then allowed the change in regulations, and so the statute was challenged, although it's true that the regulations are what implement the statute. And this is an appeal both from at this point, there's also a judgment, and this is a direct appeal on a purely constitutional issue of law. I think it does center around the statute that was passed, although that gave authority to create the regulation. That was really implementing the legislators, the statutory authority that the civil service was given. And I guess another way to look at it is, as I understand what plaintiffs are looking for, is a declaration that would say that the state could never change the percentage calculation, and that kind of statute would always be unconstitutional.
Thank you, Counsel.
May it please the Court, Alan Klinger from Strickland Levin, with my colleague Dina Kolker for the listed named judges and the state and city associations. I'd like to start.
Let me ask you this. So as I read your briefs, and you'll correct me, your position is that compensation includes wages, and includes benefits, and it includes this particular contribution that we're talking about, because compensation includes anything of value that an employer provides. Am I misunderstanding your position on that?
You're not misunderstanding, Your Honor, and I think
So if that's the case, then where do we draw the line? Because compensation must mean something, Otherwise, it means anything and everything, and we have no way to measure the parameters of the compensation clause.
Yes, Your Honor, so yes, that was what I was going to respond to your question, that what's at issue here are health benefits. And health benefits are really akin to pension in terms of both being viewed as deferred compensation. And if you look at the history of how health benefits developed, which is presented in the state's brief, is that employer-given health benefits grew out of the wage controls from World War II. When employers couldn't increase wages because of the bar on that, what they did instead is they came up with a new benefit to enhance the compensation package, which was for the employer to provide health benefits.
But they're not deferred. You said they were akin to, I mean, pension, I think we can probably agree, is akin to a deferred salary benefit. But health benefits are not deferred. That's an immediate benefit that's provided to the
No,
employee.
that's right. So for active employees, your health benefits is a form of current wage. If you look in bargaining, and that's why we cited some of the PERB cases, and we understand the Taylor law analysis is not the same thing as the compensation clause, but it's instructive, we believe. And if you look, the cases are legion out of PERB, that health benefits is part of what is a term, essential term and condition of employment. And
We're
over
talking
the,
about the compensation clause, which has a historical context.
Right.
So historically, certainly in the 1800s, you're not suggesting that the drafters thought that when they used the term compensation, they would be referring to something that didn't even exist at that time.
no, but that's right, Your Honor. It didn't exist. Employers weren't providing health
So
benefits.
isn't our task to see if whether or not this is akin to what would have been compensation at the time of the drafting?
No, Your Honor, because in 1961, there was a state constitution. It kept the term compensation. There were discussions, and this is in the record about, sometimes the council mentions salary is the same thing as compensation. Salary is not the same thing as compensation, and there were decisions out in the night before 1961 that were applying compensation more broadly.
Yeah, but those decisions were not interpreting the compensation clause. The decisions you refer to were in the context of employment cases, collective bargaining.
Yes, but Your Honor, but that as people bargain, and if you look at it, that's exactly what happened here in the challenged action, is that here it was the reverse. In order to save jobs, not have layoffs, they agreed to a reduction, they agreed to actually pay more for health care, because I think that the state has artfully presented it. If you look at what really is happening, judges are paying more for the same benefit that they had previously.
So let's assume for a moment that it is compensation, just for the purpose of this question. I read Marin to say that the compensation clause does not require the legislature to adjust salaries upward to account for inflation. That's salaries, right? With me so far?
Yes, Your Honor.
And you agree with that?
Yes, I do, because,
Okay, hold on.
okay.
So, and then if we say that health benefits are just like salary, but the price of purchasing the health benefits goes up, why doesn't Marin control this?
Because, Your Honor, what we're asking for here, and this is why I think the state is overcomplicating what's before you when it speaks about parsing, we're not, the plaintiffs here are not saying that the copays and all these parts of the plan program, like what drugs are covered, not covered, has nothing to do with our claim. What our claim here, and the reason it is different from Marin, Your Honor, is in Marin there were outside forces, inflation, that was argued by the judges there, that needed to be raised in order to stay with the marketplace.
Suppose it turns, I'm sorry.
go ahead.
Suppose it turns out, as a factual matter, that the cost to the state overall of purchasing insurance for judges is higher now than it was last year. And the state is willing to pay exactly the same contribution towards that, not more. Why is that a compensation clause violation?
I don't think it is, Your Honor. What we're saying is that the offense here, and this is why we believe it's different than Marin, is there was an affirmative legislative act taken to force judges to pay more for the same benefit without getting anything for it.
Does it matter?
That is the
That doesn't
difference from
speak to
Marin.
what the state is paying, right?
No,
No
if the-
evidence in the record about whether the state is paying more, the same, or less.
Your Honor, we're indifferent. We're not here saying, we're saying that we can't be, under the compensation clause, we can't be forced to pay more for the same benefit without getting something from it. When you go to
There's a
the,
legislative action that results in you having to carry a larger share of these costs, and that comes out of the pockets of the judges.
precisely, Your Honor.
Correct.
Does it
Okay, so
matter
let
to-
me try something else with you. Let me go back to a line of questions that were presented to the state. Explain how what you've just described puts in jeopardy the independence of the judiciary, because that's the purpose of the compensation clause.
Well, the purpose, Your Honor, is twofold. The first is
Yes.
to protect the independence of the judiciary. There's the famous Hamilton quote that I'm going to butcher that says about that the power of man's will is power over their subsistence. So that's part. And two, the second part, which has been both in the Supreme Court and the New York courts, is that for judges to feel comfortable when they take judicial employment, that they are going, if they're foregoing the higher compensation sometimes in private practice, that
Yes,
they'll
but I
feel
see-
comfortable.
Yes, that is true. You are correct, that is another purpose that has been identified. The only difficulty I have with this particular argument is that this is an optional plan. Excuse me. And the compensation clause is, again, it's very clear from the cases about what is subsistence, right? About your salary. There may be other amounts that rise to the level and put on the same footing with salary, but it's not every possible benefit that the government provides, that without it, a judge would have to pay some amount of money to get that benefit.
We agree, Your Honor. Your Honor, we're not talking about if they charge more money in the
But you have to-
cafeteria,
okay.
those type of things. But to get back to your primary question about judicial independence,
Well, when I get to, you gave me a different purpose, and my response to you was, it's an optional plan. I find it difficult to wrap my brain around an argument that's basically saying no one will apply to be a judge if the state reduces its contribution towards
Okay, but you're-
premiums that are part of an optional health care plan that, granted, the state subsidizes. You're absolutely correct about that.
yeah, but Your Honor, under the theory that's been espoused by the state, and I believe you're positing here, under that same theory, the state could just eliminate health care coverage for judges. And why would the violation be there? So that's
Well,
the problem.
it could not eliminate health care for judges alone, because that would be discriminatory legislation.
I want to get back to, I will get back to that, Your Honor, I promise. But the one thing I want to say here, in terms of the reason why we're not saying the copays and all those other things, we're not arguing that those are a value that has to be protected. But we're saying what's at issue is the provision of health care coverage. That's what's at
But
issue.
all you're saying is that something that a judge, even if it was the entire core of judges that find of some value to them, that the state can't reduce in any shape or form or otherwise take away. And before we get to whether or not that's discriminatory because it's targeting judges, it's not explaining to me how it's compensation within the context, that constitutional context of what the compensation clause was drafted to address, the evil that it was drafted to address, which is coercion.
Your Honor, where it is, I mean, why in the case Box versus Wemple that was mentioned earlier, you can make the same argument there, but this court said that no, that is protected. Instead of, we're going to have essentially a stipend instead of the reimbursement of expenses. You can make the same argument there.
Yeah, but Judge Rivera's point goes to Judge Peridotto's point. You should really address that.
I'm sorry, well, the optionality is one that.
Right, but I think that the exclusive effect on judges would be a requirement to show that a change in benefits undermines the judiciary.
Well, I think, but what it is that it could be cumulative, Your Honor, and it's not, so here, there's.
How, I guess I'm having a hard time seeing, how is this legislation any different than what the state has done year after year, and that is just to increase the cost?
No,
Every
Your
year,
Honor.
I get a notice saying it's going to cost you $25 more, or whatever, for
No,
the
because
coverage. How's that any different?
That part is not different, and we're not protesting that part. If the coverage ends up costing more money, because that's the best deal the state could negotiate with the external market, we're not complaining about that. We're saying we shouldn't have to, what we're complaining about is being told that the state is going to pay less of a contribution to it, so we have
What
to
you're
pay more.
complaining about is that the judges have to contribute more out of their pocket. There's a difference.
Yes, but it's because of an
Because
affirmative.
otherwise, it's meaningless. Your point is, judges are paying more, which means they take a hit on their salary. Otherwise, there's no argument on your side that violates the compensation clause.
No, that's right, Your Honor, but what we're complaining about here is not external market forces. We're complaining about the state having made an affirmative action that they're going to contribute less. They're going to change it from either the 100% to 90%.
How is that different from external forces that put in jeopardy the jobs of employees, right? They say it's a fiscal crisis, and they're trying to address the possible layoffs. They're trying to avoid that. That's what they're negotiating. Why are those not acceptable or proper external forces for the state to consider in this analysis?
They're appropriate for the other state employees, not for judges. The theme of the state's papers is really that judges are employees and should be treated the same way. You are not. You are constitutional officers.
But you're
You have
treated the same way for tax, right? It's not that you're not treated the same way. I mean, they could tax you, they could do the Medicare tax, right?
Right,
So it's not that you get special treatment, and now there's a new tax, but we're judges, we're not subject to that because we get less take-home pay.
so this, right, and this moves to the Hatter analysis of direct versus indirect. So just so we're clear, if it's direct, the ball game is over.
Right.
Okay. And then the one thing, just if I can quickly say.
Yeah, but under that analysis, right, they could just give the benefits to state employees, but not to judicial officers, right? Which I don't think you mean that.
But here, Your Honor, if you were to accept that health coverage is an essential benefit, not a secondary or tertiary one.
It's compensation.
Then it's compensation. Then if we have to pay more under Hatter and other cases,
Your time is out, so let's go to, what's your best argument that if this is an indirect effect on compensation, that you prevail under the Hatter analysis if we use that analysis?
is that, Your Honor, there were 4 factors that Hatter put out, in terms of this. And if you look at those factors, that they said that is there a cost to the judges? Yes, there's a cost to the judges here. It's the amount that's in the brief, it's individual. It's multiple, it's probably of 3.5 if it's for family. So there is a cost to the judges for that. Then they say, and we accept here for purposes of this argument, that state employees is the proper comparator. Medicare, one of the reasons why I think the trial level judge said what she did was that in Medicare applied to all citizens, it was the government as sovereign there. Social Security was different, because there what happened is you weren't being treated all the same. There was 96% of the federal employees could opt out of the Social Security. That left a relatively small group that couldn't.
Right.
And of that group, they said that those that had the contributory plan also didn't have an effect. The judges and some few others were the people that actually had now they had to make a payment and they got no benefit
They were
from it.
really
They
singled
carved
out.
out this 4%, which is the subclass of all federal employees that were in this different class, but then they did something else and they targeted specifically at judges. They carved out some type of pension plans that would qualify essentially as Social Security payments, and everybody else had to contribute to Social Security. Everybody else in that 4% class were mainly judges and the President of the United States, I think. So
And a few others, Your Honor.
the Vice President.
Okay, but-
So that was the problem, it seemed to me, with Hatter, and you don't have that here.
We submit that we do, Your Honor, because what we had here is that, one, we had no option. Judges had no option. You can't collectively bargain. This was imposed on the judges. The state employees, as the unionized employees that we went through, received the layoff protection and some other things. The managerial and confidential employee group, they received something for this.
But the problem, it seems to me, with the Social Security tax in Hatter wasn't that a bargain for consideration problem. It was that Congress then targeted the judges saying, well, you have this great deal, so you're going to be carved out into this separate class because your pension plan is different. So where I think the term they used was equalizing things. We're equalizing things for the judges. That's not what happened here.
Well,
They weren't equalizing because you couldn't be fired, right?
Right, that was something that the judges already had. But here, the danger here, and I think it harkens back to why we have the compensation clause protection for judges, the dangers here is that if you don't provide this protection for judges, they are going to be susceptible to these matters. The law is clear that you don't have to have an evil intent, that it can
But
be.
without the evil intent, you have to have some appearance that judges are being targeted, and I think that's where I'm struggling here a little
Well,
bit.
here, I think not that you have necessarily, none, I think it's worse than appearance, Your Honor. Judges were treated differently. Judges got nothing for this. They got no benefit.
That
for
didn't
having
hurt.
to pay
Managerial
more.
people didn't either.
I'm sorry, Your
In
Honor?
the end, the managerial people and confidential people didn't either.
But in the end, the managerial and confidential people, one got the promise of the lump sum payments, which may come to them later on. They also got
Of course,
increases in salary.
the unionized people who don't participate didn't get anything either, right? And the judges who don't participate in this plan maybe have a partner's plan that they're participating in or someone else's plan. They're not taking the hit, so.
Well, but I think, but if you stay on that point, Your Honor, and this is what I was trying to say before, when you were questioning whether this really should be looked at as wages, and this is in the record page.
Well, it's compensation.
Okay, I'm sorry.
Salary.
Well, akin to salary, because on the record, if you were to look at pages 190 and page 109, page 190 is an OCA memo to the judges when this happened, where the judges were told that if they opt out of the health care, they will get a lump sum payment. And then if you look at pages 109 of the record, it makes clear from the health system that that lump sum payment is going to be taxable to them as income. That is why, Your Honors, we're saying that we feel that we fall within the first part, because, and by the way, Your Honor, they only let you opt out if you show them that you have alternative coverage. That is in the record on pages 190 and 109. If this wasn't to be viewed as akin to salary, why, if you opted out, would they be providing you with cash and they're telling you that it's taxable as income?
Counsel, just to be clear, before this and now, you're not arguing that this court doesn't have jurisdiction to hear a direct appeal, are you?
We are not, Your Honor.
Okay, thank you, counsel.
I'd like to make.
So is there a category of essential benefits that should be on the same footing as salary for purposes of the compensation clause?
There might be, and this court doesn't have to decide that question, because I think it is important to look at what's being challenged here, because with coverage, health benefit coverage is not being challenged here. Employees still get health benefit coverage. They actually get better coverage than they did before the changes in 2011. What's being challenged here is the percentage contribution rate, and that is not itself direct compensation, and it should not be viewed as a direct diminishment. It should not be in that box.
Doesn't that bring you back to what if you change the percent contribution for a pension plan? If the pension plan's considered compensation, arguably it's bad. If it's not, then you get into a different analysis. So is it really so much what they're changing, or is it first whether or not this is compensation or isn't it?
There is a threshold determination of what compensation are we talking about, and is this it? And I just don't think the court has to decide in this case whether there might be some aspect of health benefit coverage that is so great that it could be considered compensation.
So your point is, even if we do the analysis that this is an indirect hit on the judges, it still is non-discriminatory. So that's why you say we don't have to get to that issue?
Well, as long as you decide that this is an indirect hit to either the salary or some form of health benefit compensation, if you thought that existed, then you do have to decide that it's non-discriminatory. And I'd like to get to that point. I think looking at who negotiated and who didn't and who had what other terms and conditions at the same time fundamentally misconstrues the analysis, because negotiating, who can negotiate and who has other terms and conditions are controlled by the Constitution, and it's controlled by other statutes like the Taylor Law. And if you want to look at the big picture and not just the actual financial issue, in the big picture, everybody's salaries went through the correct and appropriate process. For unions, that's negotiation. For judges, that's the committee on compensation. And for MC employees, that's a combination of legislative action and budgetary discretion. Everyone got the appropriate process. That's how you should be comparing them. You can't look at who's negotiating or not, because unionized employees always negotiate with the state, and judges never negotiate
Just to
with
go
the
back
state.
to one point here, so if this, we say, is in a direct effect, this isn't compensation, do you agree then it is an indirect effect on compensation?
It is an indirect effect on salary, for sure. I think we can agree with that. And it is a non-discriminatory indirect effect on salary. And the idea that judges paid more to get nothing, I think is just fundamentally incorrect. You have to look at the fact that judges still got health benefits. At the end of the day, they got different benefits, better benefits than pre-change. And at the end of the day, there were a lot of other things on the table that unionized and MC employees lost out on. There were salary reductions, furloughs. MC employees got hit with a salary deficit reduction plan. Judges, in the end, they had those protections not because there was discriminatory treatment in terms of the 2011 law, but because they have constitutional protections to
But
begin.
doesn't that get a little bit into equalizing? They had these other benefits, so you should take this hit on your contribution to...
No, Your Honor, this is very different from what happened in the Social Security tax in Hatter. The upshot in Hatter was that judges were pretty much the only employees who did not have an individual option to just choose not to pay the tax at all. That, and they said, and the government tried to justify that by saying, oh, the judges actually have a protected retirement benefit, and we're specifically trying to make up for that protected benefit. That is nothing like what's going on here. No employee has an individual option to not pay the higher percentage rates. There were unionized bargaining, and once the unions reached a deal, everybody has to pay. There's no individual choice, and nobody was trying to offset some protection that judges already had. They're being treated the same as everyone to begin with.
Can you comment on his point about the lump sum?
The opt-out payment? Yes. Well, the opt-out payment is something different. It's not being challenged here. The opt-out payment actually has more characteristics to a salary than the percentage contribution, because it is paid directly to judges and goes right into their pocketbooks. But one thing I'd like to emphasize is that the opt-out payment is not connected to the price of premiums, really. The opt-out payment is much, much lower than the cost of premiums. And what it is a separate incentive program to try to get people to not take the state's insurance to begin with.
Thank you.